Assalamualaikum. My name is Shahirah Binti Ahmad Fadrizah. In this video, I will present about war crimes. For introduction, a war crime is a breach of the laws of war that makes an individual criminally responsible for actions by enemy soldiers in action, such as killing civilians or prisoners of war on purpose, torturing, taking hostage, destroying civilians' property without good reasons, lying, wartime sexual violence, pillaging, and for anyone in the leadership structure who order an attempt to commit mass killing, such as genocide. The legal idea of war crimes arose from the formulation of customary international law applicable to battle between sovereign nations, such as the Labor Code 1863 of the Union Army during the American Civil War and the Hague Conventions 1899 and 1907 for international war. Following World War II, the war crime trials of the leaders of the Axis countries created the numbered principle of law, such as the fact that the international criminal law defines what constitutes a war crime. In 1949, the Geneva Convention specifically recognized new war crimes and recognized governments' authority over war criminals. In the late 20th and early 21st century, international court extrapolated and defined more types of civil war relevant war crimes. There are four Geneva Conventions of 12 August 1949 and there are two extra protocols of 1977, and this is the most universally recognized source of rules for the conduct of war. Nearly every nation on earth, including the United States, is a signatory to the Geneva Conventions. This accord formalized many of the most important principles of international law regarding war crimes. These rules have been integrated into the Uniform Code of Military Justice as part of U.S. national law. Each party is required by the Geneva Convention to avoid and punish violations of their regulation. When they recognize and define grave violations, they incorporate a component of criminal law directly. First, the parties agreed to enact legislation under their domestic law to criminalize this grave violation. Second, to search for those suspected of committing them. And third, to either prosecute them or extradite them to a party that will do so. The enforcement mechanism applicable to this grave violation serve as a model for future treaties defining international crimes, including the Convention Against Torture. Next point is International Criminal Court. Article 12 of the Rome Statute says that if a citizen of a country that did sign the treaty is accused of committing a crime on the territory of a state party, the country has the right to prosecute them. In the legislation that created the International Criminal Court, the following acts are designated as crimes against humanity. First, for the grave breaches of the Geneva Convention, willfully killing or causing great suffering or serious injury to body or health. Second, torture or inhuman treatment. Unlawful wanton destruction or appropriation of property. Forcing a prisoner of war to serve in the forces of a hostile power. Depriving a prisoner of war of a fair trial, unlawful deportation, confinement, or transfer, taking hostages, directing attack against civilians, directing attacks against humanitarian workers or UN peacekeepers, and killing a surrendered combatant, misusing a flag or of truce, a flag or uniform of the enemy, settlement of occupied territory, deportation of inhabitants of occupied territory, using poison weapons, using civilians as shield, using child soldier, firing upon a combat medic with clear insignia, and that is under grave breaches of the Geneva Convention. As for the part of a non-international conflict, they are murder, cruel or degrading treatment and torture, directing attack against civilians, humanitarian worker or UN peacekeeper, and they act as part of an international conflict are taking hostages. Next explanation is about what extent civil deaths are permissible. The killing of civilians is not always a breach of the law of armed conflict, as there are several factors to consider. Although civilians are off, Although civilians are off limits as target, it may be legal to accidentally kill or injure them during an attack on a military target if the circumstances warrant it. For example, due to proportionality or military necessity. Adequate military necessity permits the loss of life of person whose death is accidentally and unavoidable by the armed conflict of war. It does not permit the killing of innocent residents for reason of revenge or the satisfaction of a patient to kill. For the destruction of private property to be justified, it must be required by the necessity of war. For instance, if we look, a farmer is ploughing a field nearby, it should not preclude an operation against an ammunition stockpile or a terrorist training camp, as the farmer is not the target of the strike, and the operation is justified by the requirement of proportionality and military necessity. However, a massive military benefit will be required to justify an operation with risks of thousands of civilians' death or injuries as collateral damage. The question of whether the expected accidental harm is excessive in grey instances can be highly contextual. This is why many jurisdictions use a clearly excessive threshold to determine whether or not a criminal breach has occurred. Therefore, a proportionality examination is unnecessary when there is no justification for military action, such as when civilians are made the object of assault. Next, International Criminal Tribunal for the former Yugoslavia. In the case of the former Yugoslavia, NATO pilot strike the Chinese embassy in Belgrade, which was a civilian building and had nothing to do with the military. However, the pilot had no way of knowing this other than what they were told. The committee decided that the aircrew involved in the attack should not be blamed, since they were given the incorrect target, and that it is not fair to try to hold the senior leaders criminally responsible for the incident because officials of another agency gave them wrong information. The report also said that much of the information given to the OTP consisted of reports that civilians had been killed, which often led people to think that crimes had been committed as a result. Civilians can be killed or hurt accidentally, and civilian property can be damaged for a number of different reasons. Furthermore, the charges against LRA leader confirmed by ICC. The Lord's Resistance Army, a rebel group with bases in northern Uganda, declared war on the central government of Uganda in the late 80s. Their stated goal was to topple the government of Yoweri Museveni, who had led the National Resistance Army to power in Uganda in 1989. There has been intermittent conflict between Joseph Kony Lord's Resistance Army and the Uganda government, which has launched multiple military attacks against the RA over the years, primarily in northern Uganda, but also in neighboring areas of Uganda, Sudan or South Sudan, the Democratic Republic of the Congo, and the Central African Republic, and civilian has been a frequent and easy target during this protracted battle, and many have been killed or injured as a direct result. Several charges against Dominic Ongwen, leader of the Lord Resistance Army, were upheld by the International Criminal Court's Pre-Trial Chamber 2. In this case, it focused on investigate whether or not the following war crimes were actually committed, such as pillaging, committing rape and forced pregnancy, conscripting or enlisting children under the age of 15 years into armed forces or groups, using children under the age of 15 years as active participants in hostilities, destroying the property of an adversary when suicidal, and destroying property of an adversary when suicidal. And the pre-trial Chamber 2 also upheld the accusation of common responsibility against Mr. Ongwen for failing to take all the necessary and appropriate measures to prevent or control the commission of the offences, or to submit the matter to relevant authorities for investigation and prosecution. The chamber determined that the atrocities occurred throughout the course of the internal conflict between the LRA and the government of Uganda. Next is Soviet war crimes. From 1919 through 1991, the Soviet Union and its armed forces committed numerous war crimes and crimes against humanity, including atrocities performed by the Red Army, later termed the Soviet Army, and the NKVD, particularly acts committed by the NKVD's internal troops. These atrocities occurred under the early Soviet government's program of Red Terror, which in certain cases was ordered by Soviet leader Joseph Stalin. In other cases, Soviet soldiers engaged in partisan warfare or perpetrated atrocities against POW or civilians in countries at war with the USSR when they had no instruction to do so. And many of these atrocities, such as the Katy massacre and the mass raid by Red Army troops in territories they conquered, occur in northern, central, and eastern Europe shortly before and during the aftermath of World War II. However, despite the fact that the Soviet Union actively participated in the judicial processes of the International Military Tribunal established by the Allied power after World War II to investigate war crimes committed by Nazi Germany, no investigation was conducted into the action of the Allied forces, and no charges were ever brought against its troops, because they were also an undefeated power, which then held Europe in a military occupation. thereby tainting the historical authority of the tribunal. Russian nationals were held accountable in 1990s and 2000 for war crimes committed by Russian forces during and immediately after World War II in the Baltic republics. These crimes include the killing or expulsion of civilians. The current Russian administration practices historical revisionism. Crimes against humanity and war crimes are dismissed by Russian media as a Western fantasy, while in Russian history texts, they are either rewritten to paint a more favorable picture of the Soviet or are simply left out altogether. Putin acknowledged the horror of Stalinism in 2017, but he also denounced the excessive demonization of settling by Russian opponents. In conclusion, there are also rules in war. The military should not target non-combatants such as civilians, medical personnel, and others. It's a war crime to intentionally harm civilians. If those in charge have ordered or disregarded war crimes committed by their troops, they will face punishment as well. Justice for victims' family can be achieved by prompt investigation into war crimes and punishment of perpetrators. There is always the option of going to war, and it's always the wrong one. It's a decision that can only result in greater fighting. Neither our genetic makeup nor our inherent humanity requires it. It's not the only way to deal with conflicts. The conflicts are best diffused and resolved via non-violent action and resistance. However, opting for non-violence should be put off until a crisis arises. That's all from me. Thank you.